one of the proud promises of the civilized world has always been law, order, peace, and discipline, have long formed the basis on which countries were classified as first world or third world.
People in the West are a little bit tired from the decades of peace, democracy, wealth, and freedom. It is for themselves a little bit boring.
Administrative justice in Ukraine is a sphere in which the resilience of the rule of law is tested on a daily basis.
The Supreme Court of Sri Lanka found the former executive of this country liable for breach of constitutional duties. Rule of law has been advanced in its full plenitude in Sri Lanka.
Even the highest office be subjected to constitutional scrutiny.
We are judges, we are not political actors, and our duty is to protect the rights and the law under the Constitution.
Across Europe and indeed globally, narratives questioning the legitimacy of courts have intensified. The chilling effect of this type of action against the judges is a red line not to be crossed.
In Hungary, judges are not allowed to express political views.
Why is defiance of the rule of law gaining political appeal across the world?
Rest assured that the judiciary holds the final move.
We can uphold the rule of law only to a limited extent by our judgments and opinions, but we do not have means to enforce them.
Politicians must not interfere with the substance of judicial decision, but the organization and financing of the courts is a democratic issue too.
For one, never ever give up.
We simply need an openness to listen.
Thanks to Global South Network, which allow us to believe in a better world of the rule of law.
It's a wonderful initiative.
The Global South Network opened new horizons for judicial cooperations.
Global South Network provide a platform for meaningful dialogue and cooperation, fostering efforts to build a more equitable and resilient legal landscape.
GSN Network continues to expand areas of activity, further strengthening its impact and reach.
The universal concept of justice compels us to join our efforts, and this is the forum for promoting the same goal.
Well deserved for the hectic activity you have made. I am astonished, I am amazed, I was impressed.
May I at the outset commend you, Dr. Reayat, for the immense work that you're doing in the GSN. The Global South Network is a much admired initiative.
It's commendable. South Network focuses on all disciplines and regions, creating a bridge between academia, civil society, legal community, etc.
Let me invite next discussant, the Honourable Justice Ihor Dashutin, President of the Administrative Cassation Court, Supreme Court of Ukraine, to deliver his response to the guest lecture.
Dear colleagues, dear participants of the event, it is a great honor for me to represent the system of administrative justice in Ukraine and to have the opportunity to outline the stages of its development. as well as the role and activities of the Administrative Cassation Court within the Supreme Court. Administrative justice in Ukraine as a distinct branch of the judiciary began to take institutional form following the adoption of the Code of Administrative Justice of Ukraine in 2005. A major transformation occurred as a result of the judicial reform carried out in 2016-2017, during which the judicial system was reorganized and a new Supreme Court was established. To briefly outline the structure of the Supreme Court, it is the highest judicial body in the judicial system of Ukraine. It consists of the Grand Chamber, the Administrative Cassation Court, the Commercial Cassation Court, the Criminal Cassation Court, and the Civil Cassation Court. On the 15th of December 2017, the Supreme Court commenced administering justice in its new institutional structure. Since that time, the Administrative Cassation Court within the Supreme Court has been exercising cassation review in administrative cases and has also been a court of first and appellate instances in cases defined by procedural legislation. The principal mission of the Administrative Cassation Court is to ensure the consistency and uniformity of judicial practice, as well as to develop legal positions in the field of public law relations. On the 8th of December 2025, the meeting of judges of the Administrative Cassation Court within the Supreme Court elected me the President of the Administrative Cassation Court by secret ballot. The Administrative Cassation Court within the Supreme Court is structured in specialized judicial chambers responsible for distinct categories of administrative cases. The judicial chambers for cases on taxes, fees, and other mandatory payments, 12 judges. The judicial chambers for cases on the protection of social rights, 13 judges. The judicial chambers for cases on the electoral process and referendums, and the protection of political rights of citizens, 13 judges. Issues relating of the internal functioning of the court are resolved by meeting of judges of the Administrative Cassation Court within the Supreme Court. This meeting adopts collegial decisions concerning the organization of courts' work and the efficient administration of justice. As of the end of February 2026, the actual number of judges serving at the Administrative Cassation Court within the Supreme Court is 43. Allow me to briefly refer to several figures illustrating the court's workload. With regard to procedural activity in 2025, the Administrative Cassation Court received approximately 57 cases, 1,000 cases, and other procedural documents, which accounts for more than 59% of the total caseload of the Supreme Court. This trend has remained stable throughout the operation of the renewed Supreme Court and demonstrates the significant role of administrative justice in ensuring the uniformity of case law and the development of consistent legal positions. Allow me to conclude with the following observation. Administrative justice in Ukraine is not merely a mechanism for dispute resolution. It is a sphere in which the resilience of the rule of law is tested on a daily basis. Today, the Administrative Cassation Court within the Supreme Court serves as an institution that shapes the standards of public administration, defines the limits of state discretion, and maintains a fair balance between the public interest and the protection of human rights. In the context of war and the ongoing transformation associated with European integration, administrative justice has become one of the key guarantors of legal stability. Professional international dialogues such as today's are therefore essential not only for the exchange of experience, but also for the gradual and consistent development of a common European legal space. I am grateful for the opportunity for participate in such a constructive dialogues. Thank you for your attention.
Thank you, the Honourable Justice Ihor Dashutin from the Supreme Court of Ukraine, for delivering your response. Very insightful.